we will be able to replay the session. Overseeing the technical side of things today will be ADM organisers Kylas, Alan and Penny from ADM, should anything go wrong. For example, sometimes I can lose connection where I live, in which case Alan will pick things up and jump in for me until I'm back online. Kylas will put everyone on mute to begin with, so just to minimise the background noise as mentioned previously. And for example, my cat at around 4 o'clock every day now, I've noticed that she insists jumping on my desk, sitting on my laptop, and it's purely for attention, of course. So some of you may have husbands, partners who behave in a similar way, who knows? You're very welcome to ask questions throughout this session. If you hover your mouse towards the bottom of the screen, you'll see the options available to you. For example, if you're connected via Teams, you can click on the chat bubble, and this will allow you to type in a question for Amanda to answer at some point during the session. When Amanda's ready to take a question as we go along, she will let me know, and then I can read questions out to her. If you click on the hand symbol, it will allow you to sort of ask a question personally. We'll take it that you would like to ask that personally. We'll bring you into the session and show obviously your picture, and you can ask your question personally. Just remember to unmute yourself before asking your question. I do actually have a few questions that have been sent in advance of the session, and we'll get to them as we go along, and I'll be prompted by Amanda in that regard. Towards the end of the webinar, Kylas will add Furley Page's website address into the chat box, because their website is packed full of useful information that could be really beneficial to you. So at this point, I'll hand over to you, Amanda.
Okay, thank you, Linda, and welcome everybody. Thanks for attending. So on Tuesday this week, the Prime Minister announced probably one of the biggest relaxation that we've seen on the restrictions on businesses since the lockdown began more than 3 months ago. And it's actually going into lockdown was relatively easy. Coming out is like navigating through the matrix. It's really quite complicated. So from the 4th of July, we know that the majority of businesses in the UK, and with a few notable exceptions, are able to open. So pubs and restaurants will be able to serve again. Limited table service, barbers and hairdressers will open. COVID-19, however, hasn't gone away. There's still a significant risk. We are far away from getting a vaccine, and yet the workplaces are opening. So to start off with, what I thought I'd look at is what is the guidance, the government guidance, and what is actually the legal position. There's actually a plethora of guidance out there from the government. And what I would say is you don't have to follow it. It's guidance, but a failure to follow it is likely to have legal implications, as you will see as we go on. Now, you've got ACAS guidance. If you're an employer, do look on ACAS's website. It's got quite useful coronavirus advice for employees and employers. Your employees will be reading this sort of thing and coming back to you on it, so you'll want to have that guidance printed out. You've also got Health and Safety Executive. They've issued some guidance. And then the government, of course, on its website has guidance which is updated on a very regular basis. Working safely during coronavirus was initially published on the 11th of May, and it's frequently updated. And then you've got the COVID-19 Secure Guidelines. Now, these COVID Secure Guidelines have actually been the result of engagement between the government and Health and Safety Executive and industry specialists. You've got unions and so on. And these guidelines, they link 5 steps to working safely. You've got different industry-specific guidance, and I think I'm not telling anybody anything they probably don't know. So you've got, Paul will be aware, for example, that there's industry-specific guidance for construction. You're in the construction industry. You've got education and childcare, warehouses, and they've recently been updated. So go onto the government website and look at the COVID-19 Secure Guidelines for your industry in particular, because it's recently been updated in the last week to include bars, restaurants, takeaway services, van deliveries, and so on. Heritage locations I saw was included. Now, as I said just a moment ago, it's up to an employer to interpret this guidance as it wants to, okay? But you would really be advised to follow it because of the legal implications of not following it. Also, if you're opening a workplace nationally, if you're a national organisation, business, remember that public health is a devolved matter. So whatever guidance you're looking at when opening, make sure that you familiarise yourself with similar guidance for Wales, Scotland and Northern Ireland. I'm going to start off by saying a few points on the 5 basic guide steps that needs to be taken before any business is open. And although you have the industry specific guidance, there's consistency with this, okay? First of all, there has to be a risk assessment which is taken of the workplace before it opens, and this must be done in consultation with staff. It says, so if there's a recognised trade union, if you've got health and safety committee, if you have employee elected representatives, you need to be consulting with them when you do that risk assessment. The risk assessment has to be published on your website if you've got more than 50 staff, and a certificate should also be published, so the information needs to be available. I'm going to be making a big deal in today's session about the importance of communication. I'm really going to be emphasizing it because there's so much advice out there, and a lot of people are asking me, well, we're doing everything and the staff are not happy. But I think that the staff, one of the problems which arises is they're not aware of what employer is doing, because we often get this tunnel vision where we're firefighting, we're trying to prepare, make the workplace safe to open, but how much of that has been communicated with the employee? So the first thing is the risk assessment should be done in consultation with staff. That's really important, and also with health and safety executives. The second thing is to develop cleaning, hand washing and hygiene procedures, which you will no doubt be aware of. Now, the third thing, this is interesting, and this has not changed from the 11th of May, help people to work from home if they can with the equipment needed to do it. So what we are seeing is, although workplaces are opening, hairdressers can't work from home, or nor can waitresses and so on, or waiters. But if you're in a position like myself or Linda or somebody who can be home-based, that is the guidance for the moment, and I don't know how long that's going to remain in place until a vaccine is discovered. It's also really important for people who have been shielding, who are in extremely vulnerable positions clinically, and for people who are vulnerable. So definitely take that on board. Help people to work from home with risk assessments and equipment needed to if you can. The fourth one, slightly contradictory from what we heard on Tuesday, it says maintain 2 meter social distancing in the workplace where possible. Now this extends not just to your office where people might be sitting, or factory or so on, but also to canteens, to breakout rooms, to entrances and exits, you know. That you would really are encouraged to use that 2 meter social distancing. You can use floor tape, you can use duct tape or whatever to demarcate different areas, but it still recommends 2 meter social distancing. And if you can't, the fifth is that if you can't maintain the distancing, decide whether your activity needs to continue. Now, I appreciate there are people here, Tim, I heard from you earlier from Caldecott, you can't be closed. You've got children's foster care services and homes and so on. So I do appreciate there's quite a lot of people here who that might not be applicable to. But in a nutshell, that is the 5 steps. You've got the risk assessment, develop hygiene procedures, help people work from home if you can, maintain 2 meter social distancing, and then decide if you can't maintain 2 meter social distancing, whether the activity has to continue. And if it does, then you want to be looking at screens and barriers and staggering working shifts and keeping the activity time as short as possible. They also recommend keep teams together. So in the past, historically, you might have moved teams around. Whereas if you were in one team now, let's say it was me, Linda and Jane in a team together, we would stay in that team to minimize the risks of working, lots of different people being exposed to each other. Now, I just want to say a few words about social distancing, because the May guidelines, it does remain applicable to workplaces, which advocates 2 meters for safe distancing. So where on earth did this 1 meter plus come in on Tuesday this week, or Monday? I think it was Tuesday, with the Prime Minister's announcement. Well, the Prime Minister's announcement, the way on the reading I've done, is really to help facilitate the opening of businesses which simply can't maintain 2 meters. So if you're looking at restaurants, for example, or hairdressers, what it actually says is that it can be relaxed down to 1 meter plus, as long as additional steps are taken to mitigate the risk of transmission. And these steps are avoid face-to-face seating if at all possible. So if you're in an office sort of space, you want to avoid face-to-face seating. You want to reduce the number of people in enclosed spaces so you can have people spread out more, all the better. Use protective screens if you have to, and improve the ventilation, and keep staff in set work teams. That's the point I made a moment ago. Okay, so there is this question about consistency, and you're going to get that with the government guidance coming out. But my advice would be, if you can keep people at home, you can maintain social distancing for 2 meters, please try and do this. Now, I just want to say a bit now about the importance of communication, and then a few words about PPE before we move on to the next step. You can't underestimate how important it is to communicate with staff. And the government's own guidance makes this point, which was recently published this week. It says employers have a duty to consult with their people on health and safety. I'm just going to read it. It's the people who do the work who are often the best people to understand the risks in the workplace, and they will have a view on how to work safely. Involving them in making decisions shows that you take their health and safety seriously. You must consult with a health and safety rep selected by a recognised trade union, or if there isn't one, chosen by the workers. As an employer, you cannot decide who the reps will be, so you need to allow the staff to elect their own employee representatives for the purposes of consulting on health and safety, and on other matters as well, such as redundancy, which I will not talk on today, but they've got to elect their own reps. You've also got to look at the management and health and safety at work regulations, 1999. You can't delegate your employer's health and safety staff out to other people. A couple of people have asked me, actually, can they ask staff to sign a waiver, when they're returning to work? I wouldn't advise that, because the primary responsibility to ensure health and safety rests on the employer, and that goes with risk assessments, with communicating those to staff, and implementing the measures. Implementation is really important. And if you're struggling and you've got an office or something, go take it slow, open the workplace slowly, do a trial run with a few people, but do not try and delegate that responsibility on to the employees. There was a question I had about PPE. Do businesses have to provide personal protective equipment, masks and so on? Well, apart from some businesses will already have PPE in place, steel toe shoes and so on. Maybe in the construction industry, you'll have hats, hard hats, masks in certain industries and so on. Obviously, that is unaffected. But unless you're in a clinical setting, the guidance actually is that you shouldn't provide PPE as a way of managing COVID-19. And the reason for this is because COVID-19 needs to be managed through other means, like social distancing, hand washing, hygiene sanitizers, and teams working with ventilation and in little set groups. It should not be managed by a mask. I think the thing is there, people are thinking, well, if I just put a mask on, everything will be okay. That's not the way to manage it. That has its place, but you are not obliged to provide additional PPE under the guidance. So what will then happen? What happens if you're now ready, you've done all the risk assessments, you are ready to open for business, and the employees decide they don't want to come back? Are there any grounds? Okay, well, it's really interesting because we've become as employment lawyers familiar with two sections of the Employment Rights Act, and you can look this up online if you do a Google search. Employment Rights Act 1996, that's what you're looking out for, sections 44 and 100. Okay, sections 44 and 100 of the Employment Rights Act. Nobody really knew about them before COVID-19. I mean, we knew about it, but it was just something that we didn't advise on very often. I'm going to read what section 44 says. Section 44 relates to a detriment, and section 100 to dismissals. Those of you who are familiar with whistleblowing will be probably familiar with similar terminology which is used in Public Interest Disclosure Act. What it says is in section 44, an employee has the right not to be subjected to any detriment by his employer done on the grounds that, in circumstances of danger, which the employee reasonably believed to be serious and imminent, and which could not reasonably be expected to avert, he left or proposed to leave his place of work or any dangerous part of his place of work. Now, this is being recorded, but I'll just read it again. So, employee has the right not to be subjected to a detriment, also has the right not to be dismissed by his employer, done on the grounds that in circumstances of danger, where the employee reasonably believes there's serious and imminent, he left or proposed to leave or refused to return to his place of work or any dangerous part of the place of work. Now, these are day one rights. Some of you who are familiar with employment law will know that you only get certain employment rights after 2 years, like the right to unfair dismissal, for example, not to be unfairly dismissed, rather. These rights, to not be subjected to a detriment, apply from the very first day that you come into the office. So they apply to everybody. A few key concepts I thought I'd highlight, Linda. I mean, for example, what is a detriment? Well, a detriment could be refusal to pay a member of staff. Somebody feels they're in imminent danger, they go home, and the employer refuses to pay them. Now, I mentioned circumstances of danger. So the very first sentence said, in circumstances of danger, the employee leaves. Circumstances of danger is what we call an objective test. And it's likely a worker will be able to establish there are real circumstances of danger if your workplace hasn't had a risk assessment. I know that there are some workplaces out there who are allowing employees to drift in and out. They've told people work at home, they're allowing people to sort of drift in and out when they feel like it, and a risk assessment hasn't really taken place. Now, if that's happening, other employees in that workplace, particularly those in the vulnerable category, they might be frontline staff or they might be living with somebody who is clinically vulnerable, they could object. They could say, I've seen Joe blogs and so on walking in and out of the workplace and a risk assessment hasn't taken place. I'm not coming back to work until you stop this or sort it out. So there you've got objective tests. So if a risk assessment hasn't taken place, or if it's taken place but it hasn't been implemented, or if it's been taken place and implemented and it hasn't been communicated to staff, people could start to say, well, I don't believe that it's safe. Now, there's the reasonable belief, and that is a subjective test. And that depends on the employee and their understanding of whether the workplace is is safe. And that is where communication is so important, because people can get things wrong. Most of people I'm talking to today deal with staff and they're in HR positions and so on, and know how people can get mixed messages on things. We saw that from the Dominic Cummings affair that I'm not going to even start to go into because it could open up another lively debate here. But people had different opinions on what was reasonable or not, okay? So opinions can differ widely, and so it's really important when you've implemented your safety measures that you communicate to staff. Use notices to communicate, intranet, emails, communication. Train up your line managers to communicate with staff. This is absolutely critical. So just some thoughts on what factors are likely to influence the reasonableness of the belief. I've done some research on this, just a few ideas. The R factor, different geographical variations. So we may have outbreaks in different parts of the country, and they could vary from place to place. Obviously, I've just said if the employers have complied with government guidance, whether the employers introduced measures and whether it's communicated it to the workforce. It also might depend on the sector and whether it's safe and whether the work can be carried out from home. Also, the question is something I'm going to move on to in a moment. Does the employee fall into a vulnerable or clinically vulnerable group? Because they might have a reasonable belief there's danger, even if there has been a work risk assessment carried out, because they're in that clinically vulnerable group, and we have to be sensitive to that at the moment. And then, also your employees, some of your employees will be fine themselves, but they'll be living with someone who's been shielding, or they might be living with somebody who's in a vulnerable group, so someone over 70, for example, or someone with a disability. So that also influences their opinion. And then you've got to think about what is the expert opinion at the time from health specialists. We've seen, if you followed the news, this does differ from around different health specialists, but what is the leading opinion at the time? So here you can see there's an interplay between a serious situation. COVID-19 is a very serious situation, and then the individual circumstances, which are going to be bespoke to each a person. I just want to pause for a minute, and I was wondering, Linda, if there's any questions or anything that you want to ask, or I know that some ask some questions specifically about this in the feedback prior to this session.
Yeah, we've had nothing come through on the chat as yet, but obviously you have covered some issues already from some of the questions, but I just wanted to, if I may, just read those questions again so that we can just make sure that the person that offered the question is happy and there's no outstanding issues. Are you okay with that, Amanda?
Yeah, absolutely.
Yeah. So we've got actually I've got a couple of questions from Larry Tamkins. He says, we have dramatically reduced the capacity of our building, use signage, etc., to show how to move around the building, clearly taped off no-go areas, made entering and exiting the building at peak times virtually touch-free, and yet we are still being asked what we are going to do to support our employees returning to work.
This is when I was preparing, I had this question in mind, actually. I don't know what the nature of this business is, and if it's opening. It looks like what they've done is they have started to, I'm getting the impression this business has done a risk assessment and implemented those measures already. And they're taking off areas. The key here is communicate. What are we doing to support staff? I would get your line managers on board, Larry, and I'd communicate that to them to put that out to staff. I'd also put up notices around the workplace announcing what measures have been taken, and if people have access to an intranet, publish that on the intranet, because part of supporting people is telling them what you're doing to support them. So you might have done everything and it might look great, but you're going to have people who are saying, no, they don't understand what's expected of them and so on. So you know, it's really important that the communication is put out there. And also that the managers are trained up to listen to people who have very specific concerns. This is not a one-size-fits-all situation. That's something I want to emphasize. We're going to see variance because people have different health conditions and disabilities. So people will have different concerns on this. I don't know if you are here, if you're in the seminar, if you wanted just to clarify, if you have any other questions, just pop them in the chat box there.
Yeah, the other sort of question from Larry was, we're being asked, you have touched on this already, Amanda, but just to go over it again, we're being asked what support we're providing to employees who have anxiety about returning to work. How do you identify what's real and what's gaming the system?
Okay. Look, you are going to have, in any situation, including where something's been brought in or support packages have been brought in, you're going to have people who are going to take advantage of that and profit it to their own, for their own means. With sickness absence and with, we've got the track and trace coming in. For example, if you've been in contact, as you will know, if you've been in contact with someone who has COVID or you have the symptoms, you can get signed off work, for example. You can ask for evidence. I think when you're trying to establish who's gaming the system, you want to ask people for evidence of medical conditions that they may have, for example, and genuine anxieties. But I would say there's something I want to emphasize as well, and that is that as part of an employer's overall health and safety responsibilities, that extends to the welfare and mental health as well of employees. It's not just their physical health that we're trying to protect, it's mental health as well. There are a lot of people who have genuine concerns. Many people on furlough and lockdown have started to display symptoms of depression. There's people who've been subject to domestic violence. There's a whole host of things that's been happening to people while they're at home. So it hasn't been easy for them. And and then there's the stress of home working with children and schooling and so on. As much as possible, line managers need to keep in touch with staff to see that they are okay, and to maybe look at things to help them if they're in trouble. For example, you might be exploring, you can and have been able to explore furlough. And you can, if somebody already has been furloughed for 3 weeks, they can be furloughed again under the extended and new scheme, which starts in July. You might want to allow them unpaid leave and so on. Listen to people, and if you suspect that they are taking advantage of you, ask for evidence. But I think we want to approach this very much with an open mind. Okay,
and we have got sort of one on the chat if you want to take that, or so this is from Alex, a hypothetical question. What is your opinion on those with underlying conditions who are desperate to return to work? You mentioned it would not work if they signed some kind of waiver or that they'd seen the risk assessment stroke measures in place. What if they threaten to leave because of financial stroke mental well-being? And also he's come back with a little additional note here. Sorry, I want to point out for my question, not on vulnerable list, but clinically extremely vulnerable, because the guidance is up to the individual.
Okay, with clinically extremely vulnerable, I'll just move on to that. Clinically extremely vulnerable have been advised to shield at the moment. Actually, there's 2 million people shielding at the moment, I believe. And they've been told they will have received a letter from the NHS advising them to stay at home and not have contact with anybody outside their workplace. The shielding scheme, Alex, it ends on the 1st of August. Until the 1st of August, I would not allow anybody who's in that category back into work. It will be probably, even if they want to come back. And the reason for that is that the responsibility for health and safety of the workplace cannot be delegated out. It can't be delegated onto the employee. The guidance with the clinically vulnerable is very clear. If something happens to that person and they come back, your business could be in quite a lot of difficulty. After the 1st of August, the situation, as I say, does change because they are shielding is being done away with. So there's actually with this, the government has set out in its latest announcement on the 22nd of June, it set out a phasing out of the shielding sort of a system, if I could call it that. From the 6th of July until the 1st of August, those who are shielding can meet in a group of up to 6 people outside the house, as long as social distancing applies. And then they can also form a support bubble with one other household. But in that period, from the 6th of July to the 1st of August, they can't come back to work. It doesn't say you can be bringing them back into work. So I would not be looking to do that. Remember that those who are shielding, there's a whole list. If you go onto the government website, you'll see a list of what conditions they have. They're people who've had cancer, certain cancers, extreme respiratory conditions, cystic fibrosis, for example, organ transplants. I'm pretty much convinced that people who have been advised to shield probably are covered under the Equality Act 2010 as disabled people. They probably have a long-term serious health condition, so reasonable adjustments have to be made. So they're protected probably under a number of different legislations that you need to be aware of. And to bring them back to work because they want to into the physical workspace exposed to other people is ill-advised. Obviously, if they can work from home, that would be the solution to the issue. But right now, I'd say, look, the government guidance is very clear and we can't delegate out that risk. If they're feeling depressed or they want to leave, well, of course, nowhere, if they left, no other employer would let them back into the workplace if they're following government guidance in any case. Okay, it is quite hard. I know it's been very hard on people. I've been in contact with a few elderly that we support through our firm. And I spoke to one of them today and she said, I'm so down, I'm just so down. Fortunately, now her children can start to visit her, but it is tough on people. So support them with mental health as much as you can. But until the 1st of August, don't bring them back into that workplace. Yeah.
There was just one more point actually from Alex, his final point, thanking you for obviously what you've said so far, but his final one on this is there an argument for duty of care if they are coming to us about financial stroke mental well-being, or is the duty of care to follow the guidance of government overrules this?
When it comes, both really, but the duty of care, if you're asking, is the duty of care that they're so sad, so depressed, and they've got so many financial worries that can override the bringing them back into the physical workspace? The answer is no. Bringing them back into the physical workspace, the answer is very clear. You can't do that. Financial worries, a lot of people are being exposed to financial worries. They can, I've always advised and have done all along that people who are in that clinically vulnerable group can be furloughed. There's nothing in the government scheme which prevents them from being placed on furlough. And one of the ideas I was going to have for those who are clinically vulnerable when workplaces slowly reopen is, remember, the scheme is in place until the end of October. Do take advantage of it. Obviously, you can't, if somebody hasn't been furloughed, it's now too late to put them on that scheme, but do take advantage of furlough scheme for the clinically vulnerable, keeping them away from work. But in terms of emotional support, if your organisation has mental health first aiders, use it. Your organisation might also be able to direct that person to counselling support. There's plenty of mental health support advice for people with mental health conditions out there via various different organisations, and I'd signpost them. The key with supporting people in that situation is signposting them, and maybe see if you can get them to do some things from home, okay, at the moment. But bear in mind, it's only another month. Okay, before 1st of August, we're now already at the end of June, and from the 1st of August, provided steps have been put in place, you will be able to bring shielding people back. unless, of course, there's a second spike. So I'm just, and you know, the funny thing is with any advice I give on this, it changes. It's this, the advice I'm giving is as of today. What date are we today? 26th of June. It may be, Linda, you heard a talk I did, was it only 3 weeks ago from the CIA?
Yeah, it was, yeah.
That's not relevant anymore. You know? So, things change all the time. I just want to say a few words about the vulnerable as well. The vulnerable are people with less serious conditions, so people with a BMI over 40, people over 70, less serious respiratory illnesses, so they're not in the group where they have to shield. They might have a disability, they might be pregnant and so on. They can come back to work. The guidance is clear though. I'll just read what the government guidance says on them. It says, if clinically vulnerable individuals cannot work from home, they should be offered the option of the safest available on-site roles, enabling them to stay 2 meters away from others. If they have to spend time within 2 meters of others, you should carefully assess whether this involves an acceptable level of risk. And as for workplace risk, you must take into account specific duties to those with protected characteristics. So the government's again here reiterating what the Equality Act says. And it specifically says, for example, expectant mothers who are, as always, entitled to suspension on full pay if suitable alternatives cannot be found. I thought on this note I should say something a little bit about the expectant mothers. I don't know if you're aware, people are aware of this, but if a pregnant employee is at risk, if there has been a risk assessment that's been carried out and somebody's pregnant and they cannot work safely in the workspace, then there is a legal duty to suspend them on full pay. So really what you would want to be doing with pregnant employees who are exposed to an unacceptable level of risk in the workplace is get them to work from home. If they cannot work from home and there's no safe alternatives, they have the right to be suspended on full pay until the due date. That does not apply to those who are shielding or anything else. It's a specific category unique to those who are pregnant. Now, being pregnant and go, it doesn't mean that it's automatically dangerous to go into the workspace. You just have to, if you were pregnant and you also had an underlying health condition, which puts you in that extremely clinically vulnerable category, you might have to suspend them on full pay after the 1st of August. I would say just a few tips on that before I move on to the next section. You know, with those who are very, very vulnerable and vulnerable, keep them, if they are on furlough, keep them on furlough as long as you can. Allow them to work from home. Don't threaten, don't try and bring them back. Try and stagger working times when they come back so that they are exposed to as few people in the workplace as possible. I just wanted to say a few words now about traveling to work, because this is coming up a lot. People are saying, what happens if someone's workplace open, we're bringing back people, and they say, I don't want to use public transport because it's unsafe. A lot of you, it's still, if you look at the government guidance, it says, if you're traveling to work, try and use private transport and not public transport if it's all possible. And I looked at the Office for National Statistics this week, and it's published this week. It found 44% of those adults in Britain have travelled to their place of work at least once in the last 7 days, compared to 41% 2 weeks ago. So we're seeing more and more people are starting to use public transport or travelling to their place of work. Now, when you're looking at public transport, generally speaking, it's not the responsibility of the employer to do a risk assessment of the public transport. Okay, it's your risk assessment is of your workplace, not your public transport. There's very limited legal authority on this point, but there was one particular case that I'm aware of, and that was Edwards and the Secretary of State for Justice. And it concerned prison officers who refused to travel to Dartmoor prison in the vehicles which were provided by the prison, because of the snow, and the roads were so, if any of you know Dartmoor, it gets clogged, you can get heavy storms and snowstorms and so on, it's quite remote. And the roads were closed because it was so dangerous. And they said, we're not travelling to work because it's too dangerous. And they wouldn't travel in the vehicles provided by the prison. And they brought a claim under Section 44. They said, we have the right, to be paid for this time. And this went all the way to the Employment Appeal Tribunal. And the Employment Appeal Tribunal accepted that there was a danger, and it said that the Employment Tribunal had heard the case should consider the reasonable belief of each one of those workers. Now, the facts in Edwards were quite unique, and the reason for that is because the employer was actually providing the transport on that occasion. So it's different if you are providing the transport. I don't believe Edwards extends to public transport provided by the state. However, if you have somebody who's in that extremely vulnerable category or vulnerable, and they are, let's say in September on a packed tube, I could see why, when a vaccine hasn't been discovered, they wouldn't want to travel. See if you can do anything to help them, keep them at home, keep them on furlough perhaps. And then you might want to stagger the work arrival time. So is it possible, think of things like, is it possible to allow them to travel into work at off-peak times? But if this continues and the vaccine is not discovered and so on, it may be that ultimately in the long term, they cannot sustain in the workplace and their employment has to be terminated for ill health, for example. But that's not the first port of call, and nor is disciplinary action for those in that particular category. Okay, so another point is the employee's responsibility, because I've been talking so far a lot about the employer's responsibility. What about the employees? Well, you can't delegate it to them, but they do. Under the Health and Safety at Work Act 1974, employees do also have a responsibility. And this is what their responsibility is. I'm just reading from the Act. It's to take reasonable care for the health and safety of anyone who may be affected by their acts or their omissions. And it's to cooperate with their employer as far as is necessary to enable compliance with any statutory duty or requirement relating to health or safety. So employees do have a responsibility to help. So once you as a business are opening up and you're getting people back to work, you really need to communicate to the employees what acceptable standards of behaviour are. And that is in the car park at work, it's in the canteen, it's in the breakout rooms, it's in workspace, be it the factory or a warehouse or outside and so on. And it might also be appropriate to warn them very specifically and back this up in writing that if they do not adhere to these safety requirements, which is part of their responsibility to their colleagues, to you, and to your customers as well, if they don't adhere to it, it could result in disciplinary sanctions being applied. So if you've tried to implement safety measures and people are deliberately flouting them because they don't think they're important, you need to tell employees that that could in and of itself result in disciplinary actions. So yes, they do too have a part to play. We all have our parts to play in maintaining health and safety. Just a few words before I hand over to more questions about the track and trace system. Most of you will be aware of this track and trace system. It does have employment law implications. It was announced first on the 28th of May. So those people who have any symptoms of COVID-19 should present in for a test. And then what will happen is you will have a bunch of contact tracers who will contact the people that they've been in touch with, and everybody has to isolate for a period of 14 days. So you will be contacted. Okay, if that is the case, you are entitled to statutory sick pay or employers' contractual pay if applicable. Now, the impact from an employment law perspective is what this is doing is it's expanding the category of people required to self-isolate. If they can work from home, so be it, they should work from home. But if they cannot work from home, they have to stay in-house and you can't have them back at work. And they'll go on to statutory sick pay or contractual sick pay. Now, government NHS test and trace guidelines does provide some advice to employers, and it says employers really, they have a vital role to play in encouraging workers to adhere to the notifications to self-isolate and to support them when in self-isolation. One of my concerns as an employment lawyer is that if, for example, they report, they know they have to report, but they also know that they're only entitled to a statutory sick pay, and you do not have contractual sick pay in place, I worry that they might not report because they might be scared of the financial consequences. Everybody's jittery around finances at the moment. I know that people have been encouraged to go out and spend, but who knows what the long-term consequences of this are. And I fear that if people know that they're only going to get statutory sick pay, they might not report in that they've been contacted by track and trace. And then the consequences of that is you could have a COVID-19 outbreak in your workforce. So I'm going to leave people, the delegates here, to think about this. But I think that if you could possibly cover that under full pay, I'd recommend it, because I think overall the damage which could be done to a workplace of an outbreak in your workplace because someone was scared to report in could be worse. If they've been contacted by track and trace, they will provide you with the evidence. You will have evidence from the NHS and track and trace that they've been contacted. So I really would encourage you to think about keeping them maybe on full pay during that period if you can possibly afford to do it, so that they're not frightened of the financial consequences of being on a rather low statutory sick pay. But that's not an obligation. That's just my recommendation for the moment. So Linda, I'm sure that as I've continued, and I know there have been more questions, that maybe more questions have come in. Kim asked a question. I wonder if we could deal with that maybe before go on to the others. Tim from the Caldecott Foundation.
Sorry, what was that, Amanda? You just cut out there.
It was Tim's question on, it was a children's home.
Right. Yes, Tim's question was, we run a school and children's homes and can't guarantee social distancing will be adhered to by the children. In fact, we can almost guarantee that it won't. PPE is not a straightforward answer, as face coverings would not be appropriate in our settings in most cases due to communication and behavioural issues. At the same time, our services are essential and must continue, as they have done throughout the crisis. Where do we stand asking staff who are at moderate risk or live with someone who is at moderate risk or high risk to come back to work? We have put in place daily temperature checks and other measures to minimise the risk as much as possible.
Okay, it sounds like this business cannot be closed. That's the first point. Has to be opened. And it sounds as if reasonable measures have been put in place. Tim's talking about those in the vulnerable category, not the extremely vulnerable category. If you have staff in the extremely vulnerable category, they shouldn't be back yet, okay? Yes, I know with children it's almost impossible, particularly younger children, it's almost impossible to keep a social distance. Once you put those measures in place and assess the risk, obviously you can bring those in the vulnerable group back into work. I would, if you can possibly keep them in areas of that business, and this might not be practical at the moment, but try and keep them in areas of the business that are where they have less contact with the children. If you can at all do that, please do that. You might also want to put them in contact with some of the older children who are more able to adhere to the social distancing rules so that the risk is minimized. Deal with this sensitively. Obviously, particularly if they are living with somebody who's shielding, I can see their apprehension. it might be that you grant them a period of unpaid leave until the situation becomes safer, but it's one of those scenarios where it cannot be 100% risk-free. But yes, you can bring them back if they're in the vulnerable group. If they are living with someone who's shielding, they can be brought back. The legislation does not allow for statutory sick pay or sick pay for those who are living with someone who's shielding, only for the person who is shielding. So you can bring them back, but you really want to put in place as many measures as possible and possibly adjust their duties so that the risk level is minimized. It's not a perfect solution, I appreciate that.
Thank you, Amanda. Should I go on to the next question?
Sure.
So this is Richard. We are a sign and displays business keeping afloat with COVID awareness graphics, but I am sure that will still start to deplete as everyone has these items covered. We still have 3 members on furlough, 3 who have been constant, 3 who have returned. Can you tell me your thoughts on a reduction in hours, i.e. part-time? What's proposed for any resistance from staff being refurloughed on 60% or staying on furlough reduced from 80 to 60%? We are not able to top them up.
You're not able to top them up. So you can circulate people who've been furloughed. You can also bring people back part-time as of the 1st of July and share the furlough scheme with the governments. You've asked about a reduction in hours. That's something that would require a change in terms and conditions. So you need to carry out consultation with your staff with a view to changing terms and conditions permanently for everybody. And that might be the solution moving forward. But of course, if the staff object to that, it's probably likely in the future to result in some redundancies of staff. So it's a difficult one, that. But yeah, those changes couldn't be introduced. The reduction in hours could not be introduced without consultation.
Okie doke. Next question is from Paul. Regarding NHS track and tracing, our contractual sick pay does not cover a T&T situation, so presumably it's our call as an employer what we pay SSP or CSP. Yeah,
it is your call, absolutely. So with the track and trace, if they are asked to stay at home for 14 days because they've been in contact with somebody and they can't work and they do not have entitlement to contractual pay or something like that, it's your call whether you increase that. That's up to you. They are entitled to statutory sick pay only. My concern is that I just worry that people will be reluctant to tell you. That's my concern. So I might consider with your management of your organisation to make an exception, because I think that there's a business case to making an exception rather than just the law here. I think Paul, I don't know if that was Paul Bishop, but Paul, you had some other questions on furlough and statutory sick pay, I think. Linda, do you just want to read?
Yeah, I've got 2 further ones from Paul. First one is, can you furlough a sick employee on 80%?
Okay, if they become sick now, you can't do that, particularly if they haven't been furloughed before. But assuming they've been furloughed before, we've actually had quite a lot of contradictory guidance. There's been the government's coronavirus job retention scheme guidance and 2 Treasury directives, which have contradicted each other slightly. I'm going to try keep things fairly simple. If it's for short-term absences, because the employee's self-isolating, they should be paid statutory sick pay or sick pay under your contractual scheme. The furlough scheme was not intended to cover short-term absences, okay? So if somebody became sick now, I wouldn't place them on furlough, put them onto the sick pay scheme. But employees who have been furloughed for a long time, if they became sick, you can keep them on furlough. Nothing's changed on that. Long-term people on long-term sickness and furlough. If they've been on furlough, yeah, keep them. It just gets confusing if they suddenly become sick now and they are not on furlough, then you need to put them on the statutory scheme.
Lovely. Paul's second question was, if a furloughed employee becomes sick, do they stay furloughed and on 80%?
Yeah, they do. Yeah, that's right. You wouldn't take them off. There was some confusion about that at the start of the scheme, but that's been cleared up by subsequent advice and Treasury directions, so you can do that.
That's it. That's the questions so far.
You know, it's interesting because we're 2 minutes before past, so we're really bang on the time. So if anybody else wants to ask something, they can. I hope that people have found that useful. Any comments or anything before we all log off?
If there aren't any more questions, basically, you know, I think I'll start closing then, Amanda. I'd like to obviously thank you for bringing us all up to date. You were brilliant as always. Can I also thank everyone for attending and hope that you found it helpful. Kylas is going to put Furley Page's website address on there on the chat side for you, because Furley Page's website is actually packed full of information that will no doubt be beneficial to everyone. So all I need to do really is to say thank you to everyone for attending. Have a lovely weekend, keep safe and try and avoid Bournemouth Beach.
Put on sunscreen if you're going out.
Yeah, not Bournemouth Beach though.
No.
Thank you, everyone.
Thanks very much.